in the present proceedings. It would be necessary, it would only be necessary to state that the grievance of the petitioner in the present proceeding is that he had instituted an application being application number 17/2024 in GR case number 319/18 corresponding to Doimuk Police case number 15 of 2018 under section 420/468/471 IPC, presently pending before the Chief Judicial Magistrate Capital Complex before the files of Chief Judicial Magistrate Capital Complex at UPR. It is the grievance of the petitioner that the said application, although duly filed, has not been taken on record and a proceeding thereon has not been initiated by the learned trial court. Also, accordingly, he prays that a direction be issued to the learned trial court for an expeditious consideration of the said misapplication now pending before it. Also, the said prayer is not objected to by Mr. T. Sering, learned PP, appearing for the state respondent. Also, in view of the above position, considering the facts and circumstances as involved in the matter, this criminal petition is disposed of, requiring the Chief Judicial Magistrate Capital Complex at UPR to take on record the misapplication number 17/2014 filed by the present petitioner in GR case number 319/18 and thereafter to consider and dispose of the same strictly in accordance with the procedure as mandated in this connection. Full stop. With the above observations and directions, the criminal petition stands disposed of. Once a court has passed an order that it's deemed that it will be expeditiously done. Expeditiously, what do you say? I'll put in that word as 17 of 2020. 17, I'll correct it.
This is joint application.
Yeah. What about his antecedents? Those boys' antecedents, anything?
No, Your Lordship, the mobile was seized from him, Your Lordship.
I know that mobile was with his father,
Yes.
but does he have any antecedents?
No, Your Lordship.
Nothing?
Nothing.
Sure.
As far as the charge sheet states, Your
The
Lordship.
charge sheet does not reflect anything.
Not nothing.
Small boy.
Yes, and also considering that he has just passed his class 12
That
exam.
last page,
Yes.
senior school certificate examination.
Yes, Your Lordship.
Hello.
Keep-
Naam le luna.
Sir, for into application, I have
Hmm.
some enforcement of 41A notice.
You are on bail.
My lord,
Yes, madam. Have your instructions or you have something to submit today?
Joseph, they have come here for the crossing of 41 errors.
Hmm.
Instead, they could have appeared before the IO laws.
But he has already appeared.
Joseph,
You have already appeared.
that's why Joseph, no need.
What remains here?
Joseph, as far my lords can see, Joseph, 41A, that.
What
has been-
happened to that bail application? That has been disposed of.
dispose of allowed, my lord. I was
And
directed. to
you
India.
have given your statement also.
No, my lord. My statement was not recorded because I.
Because
was
you
on-
went there,
I
you
went
were
there,
not.
next, my lord,
Huh.
at page 30.
Why don't you go? You have that order. Why further order is required?
No, my lord. My case is different,
Either as it may, some transactions took place.
my lord.
Your account also, some money was deposited or taken out. Be that as it may.
My lord,
Now, in that situation, you have a bail order from this court,
my lord.
wherein it's there that you must appear before the IO
10 days.
10 days.
I appear.
You appeared before the IO
Twice.
twice. He did not record these statements.
Not record because. he was
And
on-
now the only thing is that we
My-
can direct, because that order I cannot say it to be I can't make it a nullity. I'll have to comply with that
My
order.
lord.
I'll have to require you to comply with
My-
that order.
I is my lord, to quash the impugned notice issued to me under
That-
section
That
41.
what 41 notice is what? Asking you to go there?
No, my lord, I was made as an accused person in this.
Fine,
particular case.
that is why you have a bill.
But,
You have a bill there.
my lord,
You have not challenged the FIR.
my lord, quashing of 41A.
Tantamount to,
Vis-a-vis exonerate me from the present case. And same situation, my lord. Notice was issued to me in one of the case at Guwahati also, Paltan Bazar PA.
that you have annexed.
NX, my lord. And Honorable High Court, after considering the entire material, my lord, quash the FIR so far as my part is concerned,
We will not do anything, we will only issue a notice.
my lord. I'm not seeking.
Madam, you get your,
Lordship, instruction, Lordship.
heard Mr. So-and-so learned counsel for the petitioner, also heard so-and-so learned counsel appearing for the state respondents, issue notice, returnable 4 weeks. Also, on the next day, Ms. L. Hage shall learn additional PP shall receive instructions as to shall place before this court the case copy of the case, shall place before this court the case diary, up-to-date case diary, and also shall receive a note from the investigating officer as to why the statement of the petitioner could not be recorded in spite of directions from this court as passed in the bail application filed by the petitioner herein, and also the contention of the petitioner that he had appeared, he had approached the
34.
investigating authorities on 2 occasions,
Case 30.
but for reasons as, but his statement could not be recorded. No, in the meantime, you're protected.
I'm protected.
And then-
Otherwise, my lord,
by unnecessary orders.
my lord, deeply obliged.
Obliged.
You have come all the way, that's why. I didn't know, otherwise I would have dismissed it.
My lord, deeply obliged.
Item number कितना?
Now, this application has been filed under section 482 of CRPC for quashing of.
Yes, madam, what is this 133 you have not complied with? Directly 133 you say, and you have passed a final order.
Lordship, as per Lordship,
You know,
133, Lordship. before-
the way the things are stacked,
Lordship,
it leaves room for doubt.
Lordship, 133 is a conditional order for removal of law.
This is a final order you have passed.
Lordship,
Where is
Yes.
where is that requirement requiring him to
Lordship,
make a
yes, sir,
statement?
Lordship, before passing, before go for the 138, Lordship, 137 is also the procedure where existence of public right is denied.
Madam, you
Lordship.
come to the order. Therefore, I so-and-so
Yes, sir.
in exercise of powers conferred upon me under section 133. 133 is a conditional order,
Lordship,
subject to he appearing or not,
Lordship.
giving an opportunity. Then he appears. And then you do what you want to do. But here,
Lordship, he did not appear, Lordship. As per the Lordship, they are
you
administered,
come
they
to
have,
133. But you have to confirm that under 138.
the Lordship, they have, Lordship, submitted representation, Lordship, on 15/5/24, before the
This
deputy commissioner.
representation is neither here nor there,
Lordship,
because this is already final.
Lordship.
Then
This is Lordship, this is Lordship, the order is Lordship, they have, 133, Lordship, it is a conditional order, Lordship. Lordship, 133, after.
you
this,
just tell
Lordship-
me whether this is a conditional order.
Lordship, it's, it.
It's a
it is-
final order.
Lordship,
It's a
Lordship,
final order.
yes, sir, Lordship, before coming to the procedure, do they have Lordship challenge for the why they have not so court notice, Lordship?
No, no need. No show cause is called for, but at least that 133 requires that a conditional order,
Lordship, so,
then that will be given to him.
Lordship,
If he objects so to do, appear before himself or so and so, in such, in the manner hereinafter for why the order should not be made absolute.
Lordship.
Now come to 138.
Lordship, before that 137, may kindly see, Lordship.
Procedure wherein existence of a public right, wherein an order so and so, the preventing of section so and so in use of so and so river, channel, place, the magistrate shall on appearance before him of the person. Question him as to why. That's it. Still, he will have to be given that opportunity to appear.
Lordship, no,
Have you given it
whether he had appeared or not, Lordship, that.
We
we
know
have not-
that What he says is not material. What will be revealed from the order? Where is that? So 137 also relates to an order of 133,
Lordship.
right? Under 133, once you put a conditions and then give him a notice and ask him to appear. Right?
Lordship.
If he appears either under 137 or 138, but that appearance opportunity has to be given, or is it not required? Show me. I don't know.
Lordship, as per the 137 Lordship, as per this order, Lordship, if order is passed, Lordship, he should be have,
No.
appear before the,
Where an order is made under 133 for the purpose of preventing obstruction, nuisance to the so-and-so in the use of any way, river channel place, the magistrate shall, on the appearance before him of the person against whom the order was made, question him as to whether he denies the existence of any public right in so-and-so, so-and-so, so-and-so. Finds that there is reliable evidence in support of such thing, he shall stay the proceedings. A person who has been on being questioned failed to deny the existence so-and-so, so-and-so, shall not in the subsequent provision permitted to make such denial. So everything boils down to 133. And 133 cannot be a final order, it should be a conditional order.
Lordship.
Correct me if I'm wrong.
Lordship. As
I
per this
was
order,
basically a writ man. Now you have brought me to criminal. So guide me.
because as per this order, Lordship, as he has passed under 33 laws, 133, but Lordship, as the last part, Lordship, it is directed the town will have carried out, Lordship. That is, they have directed to the town.
And madam, one thing,
Lordship.
this is not against a person or
Yes.
persons. It's just a general order.
Yes.
It can be applied to anyone under his jurisdiction, right or wrong.
Lordship.
This page 14 order is not directed against any personal, any person concerned.
Yes.
It's not he, anybody.
Lordship, that's why 133 for the general public for the Lordship.
I know
That's why
that.
it's coming.
But 133, when a so-and-so, 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 so-and-so receiving the considered with that answer should be removed in the public place, so-and-so, so-and-so, may make a conditional order requiring the person causing such so-and-so, so-and-so, carrying on such so-and-so, keeping such so-and-so, so-and-so to remove. These are the conditions.
Lordship.
Then, or if he objects to do so, appear before himself or any other magistrate subordinate to him at any time, so-and-so, and show cause in the manner hereinafter provided. Why the order should not be made absolute. It's not a 144 order. It's a 133 order.
Yeah, As
Right.
per Lordship, as per 137, this subclause. 2, Lordship.
137, madam, you read the first opening line, where an order is made under section 133. Then the rest will follow.
Lordship, as per the 137, there should be, Lordship, there's any reliable evidence, he should be some, Lordship,
I
investigation.
got it,
Lordship.
madam, I got it, but still 133 is required to be followed.
Lordship.
What, any judgment?
Yeah, Avarachan versus CV. Srinivasan case.
Wherein it said that
Passing
Passing
any
up,
order
right.
under section 133 CRPC.
Now, here also the omission part of the deputy sub-judicial magistrate to draw up a preliminary order which is a second known for initiative proceeding under section 133
what
without
did the
following
magistrate
initiative.
do with this? Your representation, anything done? Nothing.
No, you're not yet.
But
The
madam,
order
you
is
have
very-
left your things on the road. It's dangerous.
Yes, yes, Your Honor, because
And
there's,
if it rains, bikers may skid and go and hit quite.
that is why there, the retaining wall is being constructed.
I know
So
that,
as soon as
I
it
know,
is
but-
over,
but
the
you see your
materials will-
page 19 of 19 photograph, 20 photograph. This does
Yes,
not
sir.
inspire much confidence.
It's been stacked in the corner, Your Honor, but it's
Right,
not
it's at the
disturbing. the-
corner, but see, it's on the road itself.
Yes, sir, maybe Lordship, by the emergency Lordship, they have passed this order.
Your
Lordship.
Honor, the order itself is
Have you
illegal
removed
because
these
it isn't,
things? Have you revealed, say that, have you removed these things?
not yet, Your Honor.
Why?
It is in the condition that it is being
It
produced.
should not be. It should be. Undertake, we will. Public interest. Because we are not very confident with this. That order we'll look into. But see the way you have stacked your things. Human life would be at danger. There is a possibility, right?
Yes, Your Honor,
How
but
can
then
this court close its eyes to that?
there is enough space, Your Honor, I believe, if Your Honor will look at page number 20. Before it was in the condition that it has been produced in page number 19, but now it's been
Madam,
cleared out.
Madam, one rain and all this would be on the road.
Your Honor, the petitioner will make sure that it does not,
Petitioner to make sure that this is removed.
then he may be given some time, Your Honor, because it's
How
not
much time
possible.
do
The
you-
construction is still ongoing.
How much time do you want? 1 week?
Because Your Honor, if Your Honor will come to.
We'll have it on next
17.
Wednesday. You take steps. I'm forgetting all these things. I'll say no coercive action, but on Wednesday, you come and tell me with photographs that you have removed it. Will do.
No, sir.
We can't ignore such things, madam. Because it's your life, my life, anybody. Young guys, I've seen them, how they ride bikes these days. One small skid, gone. And it's all boulders, right?
Yes, sir.
Heard Miss T.Y. Bhutia, Learned Counsel, appearing for the petitioner. Also heard Miss L. Hage, Learned
Additional public.
additional PP appearing for the respondent number 1. Who is appearing for respondent? You will be appearing for respondent number 2 also,
No, sir.
for the respondents. Also, Miss Bhutia has, by drawing the attention of this court to the order passed by the respondent number 2 and available, dated 10/5/2024 and available at page 14, has submitted that the same has been so passed in violation of the provisions of section 133 CRPC read with section 137 and 138 CRPC, full stop. Ms. Hage disputes the above position and submits that the nature of the obstruction that has been created and the apprehension of loss of human life occasioning thereon had required the respondent number 2 to pass the said order dated 10/5/2024. So, be that as it may, it is stated that the procedure for passing such orders having been laid down in the provisions of the CRPC, the respondent number 2 ought not to have violated that. Accordingly, it is directed that till the next returnable date, no coercive action in the matter shall be taken against Ms. Bhutia. Also, in view of the deliberations taking place in the present proceedings, Ms. Bhutia has submitted that the petitioner would remove the obstructions as created and as revealed from the photographs brought on record by the petitioner and available at page 17 to 20 of the petition by the next returnable date and would furnish proof thereof and would furnish proof thereof. Also, in view of the above petition, list this matter for further consideration on Friday next. Madam, you do it satisfactorily, satisfied.
Next.
Show her. If she says yes, we will cost.
It may be fixed at least on the next week, Your Honor, because.
Next week, Monday. 27th. But madam, do it.
It's-
Every case will not go by legality of orders. We also will have to see what is happening.
Indeed, Your Honor.
I'd like
Your
to.
question.
Yes, case diary was, Mr. Bodo, case diary was supposed to be produced.
Yes, Your Honor.
Is this the case where the mother and 2 children? That is the case,
Yes, Your Honor.
right?
Yes, Your
Yes,
Honor.
And you are 40?
Your Honor, this is a joint petition filed by the
We
accused.
are not, we'll not. This case will not. There is a section wherein minor children were employed by you
No, Your Lordship,
and they were rescued. This FIR does not come from the mother, it comes from the Child Welfare Society, right?
yes, Your
Then,
Lordship.
yes, madam, have you got this case diary?
No, sir. I have get that, no, sir.
Your
You have not
actual-
gone through.
Lordship, I'm sorry for today,
Okay,
this morning
no
only.
problem, no problem.
Tomorrow, Lordship.
No, not tomorrow. Day after.
Your Honor,
List this matter again. Let's see, case diary, what it is there, and then we will. Otherwise, I'm not very with you in this matter, only because of that allegation.
Your Honor, this child was 17 years old. He was already working.
There are two
as-
children.
One was brought by the mother herself
No, no.
3 months back.
The allegation is both of them were there.
And Your Honor, that the one cousin sister of the complainant, she was already working with the petitioner since from 7 years.
I know.
She was already working with the petitioner since 7 years. And she brought the
13
elder son.
years, second one. Lucky Joy Sakma and Anit Kanti Sakma, 17 and 13. Both are
And-
under 18.
Your Lordship, that 13 years, that child was brought by the
Madam, you also
Mother
please, the
herself.
injury report, what is there? Okay,
No,
we'll
sir.
have it on Wednesday.
Lordship.
Your Honor, tomorrow, may it be.
You're not here.
Day after tomorrow, I will be there some other.
Friday. Friday. On the prayer of the parties, list this, Ms. L. Hage, learned additional PP submits that the case diary has been received by her. However, she prays for 2 days time to peruse the same and make her submissions there.
Lordship.
So the same is not objected to by Mr. A. Bodo, learned counsel appearing for the petitioners. List this matter on Friday,
No pleasure.
Lordship.
right?
Be please, Your Lordship.
Hmm.
Application under section.
Yes.
CD was called for.
No, you tell me.
Yes, Lordship,
Charge sheet file.
not
No,
yet, Your Lordship.
not
The
yet.
main accused, Your
Small
Lordship, who
court.
had supplied the,
Man whose possession the material
Yes,
has
yes.
been recovered, he has been granted bail.
My lord.
And this boy also.
Yes, my lord.
Give him.
Your Lordship,
Today, 110 days over. Under custody.
No, let's see what
Further detention. is
Madam
not-
Jeannie says. I'm leaving it to her.
because Your Lordship, the main accused, as far as the CD,
Ramesh Pego.
yes, Your Lord.
No, not
Not
Ramesh
Ramesh
Pego.
Pegu, Your
The
Lordship.
other one.
The other
Moniram
one.
Pegu.
Moniram Pego.
Not even Moniram Pegu, Your Lordship. If Your Lordship will see, there is another person, Rakesh Pegu, who has supplied the,
Who has got this bill at page 29?
Moniram Pegu, my lord, from whom the alleged
no,
drugs was recovered.
No, wait.
he was a pillion rider, Your Lordship. Both of them were caught together, Your Lordship. But the main
The
supplier,
Present petitioner accused,
Yes.
present accused before us
Yes.
was the driver.
yes,
And the
Yes.
other man was the pillion driver.
Billion rights.
And from his possession, the drugs were recovered, right?
yes, Your Lordship.
So he has been given bail.
The-
Default bail.
Yes.
The case herein is, Your Lordship, that they have in their own statement, Your Lordship, if Your Lordship see the statements, Your Lordship, there is another person who has supplied the material to be transported to the state, Your Lordship.
Hmm.
That person is still absconding till date.
Now, why did you not object to that bail?
Your Lordship, this bail was granted by the special judge, Your Lordship. If-
That's it. You should
Yes.
have gone for cancellation.
Yes, Your Lordship.
It's around a month now. Where are the statements? FSL is done,
Yes, Your Lordship.
positive.
Yes, Your Lordship.
He is Ramesh.
Yes, madam.
Lordship, the bail was given, the bail to Monesh Pegu has been given on the ground of default bail, Your Lordship.
What is the maximum period here?
Yes, Your Lordship, since it's a 21A, Your Lordship. Small quantity, Your Lordship, it's a 60 days period.
60.
So that is gone.
Yes, that can be a ground for the bail, Your Lordship.
We'll give you. But Mr.
You they come.
Hmm?
You they come.
You, Dekal, and counsel for the petitioner. Also heard Ms. T. Jenny, Lanak, additional PP appearing for the state respondent. Bail order है ना? Sorry, okay, fine. I'm just keeping the city, I'll give it back.
Yes.
Disposal.
Take your lights.
I think this is the first NDPS case I am giving a bail.
Yes, Your Lordship.
11, you are paying for?
No, sir.
Oh,
I'm on
11.
behalf of Deepangi.
Punning, Deepaning is for the
Petitioner.
petitioner. Do you want to file a response to the affidavit filed by 6, 7 and 8?
We have not received this
Copy.
affidavit in reply, I think.
Who is appearing for the respondent 6, 7 and 8? 6, 7 and 8, it is BK Singh. It is submitted at the bar that the affidavit as filed by the respondents number 6 to 8, that is the FCI authorities on 10/5/2024 has not been handed over to the learned councils for the petitioners. Full stop. Accordingly, list this matter again after 2 weeks. Full stop. The learned council for the respondents number 6 to 8 is hereby directed to furnish a copy of the said affidavit within a period of 2 days to the learned council for the petition. The learned council, the council petitioners are at liberty to file a rejoinder in the matter, if so advised.
Much obliged.
After 2 weeks.
Fine, please, Your Honor. But in this case, I'm appearing on behalf of Mr. T. Time, the counsel for the petitioner.
Hmm.
He's currently out of station, Your Honor, so I've been asked to seek adjournment for this case.
No, the respondents have filed an affidavit here.
Yes, Your Honor, they are challenging the maintainability of the petition.
Ah,
here.
Are you
So, for
filing
the
a,
hearing-
do you want to file a rejoinder there too?
No, Your Honor, I believe he will be arguing the matter. now.
Okay. Service is otherwise complete, I suppose.
Yes, Your Honor.
This has come for this. Is it admitted? No. Now, the coming and
It has not yet been admitted.
issue
I believe.
notice. Remote the passed earlier to continue.
Because they've raised maintainability issues, that's why.
Respondents have appeared in the matter. They have appeared and filed, I suppose.
They've not filed their affidavit in opposition, however, they've raised their preliminary
Who
objection
is
to
appearing
the.
for the respondents?
Mr. Tony Perkin.
So it is seen that the service of notice upon the sole respondent is complete and learned councils have entered appearance on their behalf. Full stop. Ms. Bhutia, learned counsel appearing for Mr. T. Time, learned counsel for the petitioner submits that they be given 2 weeks time. In as much, on account of certain personal inconvenience of Mr. T. Time. Prior accepted, list this matter again after 2 weeks.
Deeply aware.
Yes, madam.
Yes, Your Lordship,
There was one more case here. Pretty, where is
Pretty-
that? Where is
second.
that?
the one, he has withdrawn, Your Lordship.
He has withdrawn.
Yes, the another person, the bail petition was dismissed, Your Lordship.
And this is the second one.
This is the third person, Your Lordship,
Oh, this is the third
in
person.
whose account the
Money was.
money was transferred, Your Lordship. Now, Your
I've
Lordship,
got the case diary.
I have got the case diary, Your Lordship. The investigation is also on hold of the non-arrest of the other accusers, Your Lordship. They are absconding. Also, the accused in this case was granted bail on 4th of March, Your Lordship.
Hmm.
He has never come to the police station, even for
Interim bail,
execution,
yes, interim bail.
execution of the interim bail, and on repeated telephonic someone also, he is not cooperating, your lordship.
He has not appeared before the IO also,
After the interim order, your lordship,
not appeared.
not appeared.
Yes, Mr. Council.
Lordship, after the order dated 4th March, we appeared before the IO, Lordship, on 9th of
But
March.
the record says that you have not appeared.
Yes, Your Honor. Police inspector, the IO.
Why don't you sit
Okay.
comfortably, huh? Now make your submissions.
Lordship, police interrogated us. We reached police station by about 9 PM, Lordship. Thereafter, we were there till 4 PM. Police asked us, and thereafter police asked to get deposit 25,000 rupees. Thereafter, the accused was not in a position to deposit the amount, and that's why he told the police again told that if we call you again, then you have to come. And we got the photograph also, which we on 9th of March before the Simpu police station, Your Lordship.
His statement would be required.
Yes, your lordship.
If we dismiss it, he'll also abscond.
Yes, your lordship, in that case.
Yes, Mr. Council,
Lordship,
I'm giving you 10 days time.
Lordship,
Appear
Yes,
before the IO, and
Lordship.
thereafter we will take up this matter.
Lordship,
And if you don't appear this time and don't fulfill the conditions, we will reject your application.
Lordship, whether we have to deposit the amount that police asked us to deposit, 25,000.
But that is the condition here.
Security amount, we have to deposit it.
That is up to the police and you, how you satisfy that condition. We have passed an order, you comply with that. And within 7 days, you appear with that amount, deposit in the manner required, record your statements, thereafter, come back, we will see what can be done.
Lordship,
Heard Mr.
T. Bharali, Lordship.
Heard Mr. T. Bharali, Learned Counsel, appearing for the petitioner, and also Ms. T. Ginny, Learned Additional Public Prosecutor, appearing for the state respondents. Ms. Jenny from the case diary, Ms. Jenny has produced the case diary pertaining to Chimpu PS case number 13/2024, and has submitted that in terms of the directions passed by this court wide order dated 4/3/2024 granting interim bail to the petitioner herein, the petitioner had appeared before the police, before the investigating officer on for 9/3/2024, and thereafter on being asked to fulfill the bail conditions as contained in the order dated 4/3/2024, he had left the PS stating that he will appear again on 11/3/2024. It is submitted by Ms. Ginny basing on the report of the investigating officer that the petitioner thereafter had never never appeared before the never appeared before the investigating officer. Full stop. It is submitted by Ms. Ginny that the investigation in the matter is in a stalemate on account of the fact that the accused are not being able to be questioned
yes.
in the manner required. Full stop. Mr. Bharali has submitted that although he had appeared before the investigating officer on 9/3/2024 on account of the fact that he could not manage the surety amount, he was not in a position to reappear before the so-and-so. Mr. Bharali undertakes that the petitioner shall appear before the investigating officer of the case, that is Chimpu PS case number 13/2024 within
7 days.
7 days. 7 days, Mr. Bharali.
Lordship,
Today is
20.
20. That is before, on or before 28/5/2024. Full stop. List this matter again on 31/5/2024. Full stop. The case diary is returned herewith and the same would be updated and again furnished, again reproduced on 31/5/2024.
Yes, sir.
Get a report.
Yes, sir. Deep.
You appear,
Lordship.
Mr. Das. Mr. Bharali, you
Lordship,
appear.
Lordship,
Within 28, you appear. Give your statement, do what is required. If you don't do it, next time we are going to dismiss, we'll not even hear you.
Lordship,
Appear, then see what we can do. Okay?
Lordship,
Deep.
oblige Lordship.
My lord, on the last occasion, this could not be taken up due to the absence of the.
Yes, this is the case. Somebody made a mention today morning. Yes, he had made a mention about money.
No.
No, you're not made a mention. Okay. Somebody mentioned this. Who mentioned the other again? Okay. Somebody had appeared for us. You are appearing for?
I'm for respondent.
Who? Which
Ojing Pada,
respondent?
on behalf of Ojing Pada.
No, which respondent?
I'm
One,
the sole
two,
respondent.
two.
One.
One.
He is appearing on behalf
For
of the
You
specific.
don't want to file any affidavit here?
My lord, so sorry, my lord. Kindly pardon me. The counsel for the respondent, my lord, Ojing Pada, due to some unavoidable emergency.
And somebody had appeared for respondent number two.
Yes, on
But
last,
no Vakalatnama has been filed.
no, after that also on 23rd, 23/4 also no, none appeared. Ma'am.
None appeared.
Otherwise on 28th second, one vacuum Tamin he had appeared on
But
behalf.
no Vakalatnama has been filed.
No, till that no.
So what do we do with Sukhim, sir?
My lord, otherwise no, that, there's a respondent to it only the company.
Already done. So we
Yes.
need not wait for him now.
Yes.
Huh?
So my lord will,
I'll fix it
Otherwise-
for admissions.
yes, my lord, day after tomorrow, my lord. Because my lord, my basic case is that nothing has happened, my lord, and
Your Honor, my
I-
seniors
We
instruct
have
me.
very good impression about your this SIC VIG. At least afterwards, I was sitting here. Whatever matters I got, they were very, and where is Mr. Pada? He was very up and going. I liked it. So this is not expected from SIG. You do what you want to do. We'll have it after 2 weeks.
After 3 years.
No, 2 weeks. In the meantime, tell Mr. Pada that what is to be done. Otherwise, we are going to come in. Okay? Heard Mr. D. Soki, Lanark Council for the petitioner. Also heard Mr.
Team.
T. Mickey, Lanark Council appearing for O. Pada,
Yes, on behalf.
Standing Council, SIC, VIG, na?
Yes.
SIC will do.
yes, you.
SIC. Full stop. It is prayed on behalf of Mr. O. Pada that the matter be taken up after 2 weeks. Full stop. It is also to be noted that although a council had appeared on behalf of respondent number 2, however, no Vakalatnama has been filed till date on by such council, and accordingly the service on respondent number 2 being complete, this court would deem that the said respondent had, that will do. So accordingly, service being complete, list this matter again on 2 weeks, after 2 weeks, on a date to be fixed by the registry for admissions. And on that day, we will hear.
Oblige.
None appears for the petitioner on call. Hmm.
14 Lordship.
Yes. 14, who is there? You are there? Yes, madam, what is here? this is that theft. Antecedents?
Lordship.
Any antecedents?
Lordship, here Lordship, charge sheet has been submitted, Lordship.
I know that.
Was a charge
But
sheet.
is there any antecedents of these people?
Petitioner.
No, no, not there.
Lordship.
Let's not. You proceed. There is a stay button, no?
Lordship.
Okay.
Interim already granted, Lordship.
Yeah. We'll have it. You have the case there, you know?
Lordship.
Written. Heard the, none appears for the petitioner on call. Heard Ms. L. Hage, learned additional PP appearing for the respondents. The Ms. Hage submits that the case diary has been received by her. However,
No, sorry, Lordship, case has not, because already been charge sheeted, Lordship. It is before the
CGM.
the
You've
CGM
not
zero,
got it
Lordship.
back.
Lordship. It's already the charge sheet, this CD is placed before the CGM, Lordship. It's
Okay.
already charge sheeted.
Anyway, Ms. So-and-so appears, none appears, why have seen, none appears for the, none appears for the petitioner, heard Ms. L. Hage, learned counsel for the state, additional PP appearing for the respondents. For the ends of justice, registry to release this matter after 2 weeks on a date to be fixed by. Let him come.
Obliged.
My lord, here, my lord, I would insist for disposal, my lord. My lord, here, my lord, there is urgency, my lord. Why, my lord, the trial against the main accused, it's almost in the fag end of the, it's almost at the last end, my lord, stage, my lord. Here, basically, my lord, I am challenging, impugning
Yes,
the-
Ms. Hage, what do you say?
I have a judgment where the state of the concern of charge, framing of charges, Lordship. What is need to be considered, whether there is a ground for presumption that the offence has been committed or not as a ground for the conviction. The accused has been made out and law has not been permitted to mini trial Lordship, at this stage,
That's true.
Lordship.
my lord,
Lordship.
here, apparently, my lord
Hmm.
knows that at the stage of framing of charge, my lord, the learned, my lord, session judge, my lord, should not, ought not to have, my lord, considered or not to have evaluate the, my lord, the, this weightage of the, my lord, statement of the witness, my lord, and ought not to have come to the conclusion that the PW is a interested witness, my lord. My lord, that cannot be come during the, my lord, pre-trial stage, my lord, at the stage of consideration of charge. My lord, here in this case, my lord,
Mr.
will say,
Sonar,
my lord,
I'm against you. The nature of the thing.
well, I am for, my lord,
I know,
I am against the discharge, my lord,
I know that.
my lord,
I find it,
my lord,
I have been going through a certain judgments,
my lord,
applying those.
my lord.
I think this, because tomorrow, if some materials come
Madam.
against these people,
Madam.
they can always be added back. There is no problem in that. Right, madam?
Lordship, yes.
No, 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 my lord.
367, 397, what is it?
No, my lord, my lord.
Three, Lordship,
They can be added.
319, Lordship.
No, not 313.
Okay.
There is a provision under which if there is some material coming against them, they can be brought back.
The material, my lord, will come only when the person is made a accused, my lord. Because first the person
Need
is
not be, need not be, mister, need not be. That's it. It's what I was.
my lord, will see. Now, my lord, we have to see, my lord, whether this
What is that provision, madam? Mr. Raj, what is that provision?
my lord, there will come a 319,
319, your Lordship.
319.
319, Lordship.
One second.
Discharge,
That
Lordship.
is in a different context. My case in a different context altogether. I am, my lord, here challenging the legality whether that at the stage of framing of charge, whether the I am in a different stage. My case is
Only a shifting, your case would be that only a shifting is required, a detailed.
no, my lord, no, my lord. My understanding of the law is, my lord, I have some judgment in that point. 226, 227, that there is a scope and ambit, my lord. Under that provision, only the power has to be exercised. It says, my lord, if there is a prima facie materials, my lord, at that stage, the court cannot go into the question, what is the weightage of that materials? Evaluation cannot be done.
You can add one line to that.
My lord,
You can also make a submission
my lord,
in view of the order passed,
my lord.
that the trial court had also considered his defense, what his defense
No,
would be.
that's why, my
That
lord,
cannot-
now, my lord, that's why I am before my lord. My lord will see whether the power, within that power, whether the power has been properly exercised or not, my lord. Keeping in mind the principles of law, my lord, that how the power has to be exercised, my lord. Let's come to my lord, impugn order first, my lord. Page number 14, my lord.
Show me the FIR first.
FIR, my lord, you will find at page 20 to 24, my lord. FIR was lodged by the father, my lord. 22, my lord, we'll find page number 22.
Father of the deceased.
Yes, my lord. He was telephonically informed that someone had brutally assaulted. Now, FIR, my lord, unknown persons. Word is plural, my lord. It's not only one person, my lord.
Okay, come to the impugn order.
My lord. My lord will find impugn order starts from page number 40 to 20, 14 to 21, my lord.
14.
14, 1-4, my lord. Now, my lord, relevant portion to my lord, so far this accused person is concerned, my lord. Page number 17, my lord.
Just so. I found something, I'm just trying to get back. A1 still continues.
My lord, my lord. Against him, my lord, case is going on. I'm agreed by the discharge of A2 and A3.
Eyewitness was that
John Tapping.
John
The
Tapi.
injured one. He was the person who was first, my lord. He had been beaten by this person, my lord. Then he called his friend to rescue him, my lord. Then that friend came. Then these people, my lord, brutally attacked him and he succumbed out of injury, my lord. And my lord, from the medical report, my lord, can
Only
see.
witness John Tapin, with whom these three accused had quarreled before the incident of the case, and who called the deceased for his help, has stated they have beaten the deceased, which is also an improvised statement. Now, there is another statement. Including the evidence and the census, okay. Where is his 161? John Tapping's 161?
161, my lord, will find his number
Page 35, please.
35.
35.
Heard Mr. R. Sonal on the council for the petitioner and also heard Mr. Miss L. Again, Learned Council, Learned Additional PB appearing for the state respondents and
I am for the private respondent.
name, your name,
K4C.
K. Posi, Learned Council appearing for the private respondents. So, list this matter again after 10 days on a date to be fixed by the registry. Stop. For hearing. I'm just talking. I don't want to dismiss it. You are having a good day with me.
Right.
Let's close it like that. See, very sketchy. The thing is, incident took place in a room. 3 boys were the accused, they were taunting him. So he called the deceased. Deceased came. Then there is a gap. Your girlfriend goes down, finds the dead body, a body lying. Who had attacked? And you are the only witness. So why the benefit given to them should be questioned at this
No,
stage?
my lord, that is not the point to be discussed, my lord. Here is the issue.
No, I'm just talking about
Yes,
the
ma'am.
factual metrics.
My lord, investigation charge sheet says, my lord, these 3 persons jointly attacked.
I got it.
But the learned trial court.
But the only
what the-
eyewitness
what the-
is, no, Mr. Sonar, the only eyewitness is John
John Tapping. my lord.
Yes.
John Tapping's statement,
My lord.
at least prima facie,
My lord.
does not bring them in.
My lord, 164 statement. That is there. 164 statement completely.
That's why I'm
Well,
saying
the
that
problem where, my lord?
the trial court held that these are developments.
That is why the law says, my lord, at this stage, trial court doesn't have power to go into the question of consistency, contradiction, interest. Evaluation is not permitted. This is what is the my case. It is not that can come only after trial. If, my lord, before trial court sees and says this is contradiction, before putting cross-examination, then no need of trial.
After 1 week on a date to be fixed by, comes back, I'll use it. But I'm against it. 10 days ago.
This is a wrong, my lord, illegality in this case. That is not permissible.
But I
My lord, here, my lord,
see, what I have understood is that the court prima facie has to look into the matter. It has not to go deep into
my
it.
lord, well, look, how the court can come to the conclusion that John Tapping is an interested witness? He is an injured witness and has no idea what is interested in injured
Actually, he is the one who has
Who
led
is
to
the-
the death of the deceased.
My lord, the weightage has to be given to his evidence. Now the court says that he is an interested witness.
I'm sorry. You have a good day with me. Let
My
us
lord, my lord,
close on
my lord.
that.
Deeply up.